Hey everyone, welcome to my YouTube channel. I'm Joshua Ritter. I was a Los Angeles District Attorney for 10 years. I'm currently a criminal defense attorney based here in Los Angeles, and I'm the host of the Sidebar podcast presented by True Crime Daily. But I started this channel with the goal of bringing something a little different to those of you who follow the true crime world. I have navigated the criminal justice system for my entire professional life. My hope is that my experience will bring you some insights and unique thoughts you might not have considered before on these cases that we all follow so closely. Let's jump right in. This week in New York, Harvey Weinstein is back in court. Well, not Harvey Weinstein exactly, but his attorneys. This week, Harvey Weinstein's lawyers are asking the state's Court of Appeals in Albany to dismiss the disgraced movie mogul's 2020 conviction, arguing that the judge trampled his right to a fair trial by succumbing to the pressure of America's reckoning with sexual misconduct perpetrated by powerful figures. Weinstein, as we all know, once the powerful and feared studio boss behind such Oscar winners as Pulp Fiction and Shakespeare in Love, ushered in the Me Too movement. It was his character on trial, his lawyers argued, however, adding it wasn't the evidence that was on trial. All right, what's happening here? This is about character evidence. And it's unfortunate that we're talking about this very important issue when it comes to a person who is essentially a pariah at this point. The amount of evidence coming out about this man is disgraceful. But really, the issue that's at play here is whether or not somebody can be put on trial for being an awful human being or for being a criminal that's committed certain criminal acts on certain days that can be proven. We as a country have decided in the greatest criminal justice system in the world that you don't put people on trial for who they are, how bad of a person they are. You put them on trial for things that they have done. And you shouldn't be able to submit evidence into court that doesn't have anything to do with that. What are they being accused of? What is the crime itself? Now, there are exceptions. Those can be motive, opportunity, intent, or common scheme or plan. In other words, you can present other acts, uncharged acts, even other victims who aren't charged, if those people are being presented for the limited purpose of perhaps proving a person's motive or their opportunity or a common scheme or plan. That's important too. Do they seem to behave in this certain type of way again and again and again, creating a pattern that is therefore instructive to the jury to understand whether or not they committed the crimes charged in this case. In Weinstein's case, his defense is arguing that 3 uncharged women were able to have testified, and that essentially a jury, even if those women, their allegations weren't proved beyond a reasonable doubt, that evidence was so crucial to the prosecution, so motivating, that he was convicted on these uncharged crimes rather than the evidence of the crimes itself. And again, we're talking about horrible allegations involving a person, a horrible person, but the issue remains the same of if the act he is charged with, the crime he is charged with, is not that strong, and you're going to bring in a bunch of other people that you really aren't charging him with, but just to dirty up his character, are jurors going to do the same thing we all do, where you hear somebody's been accused of something, you say that that sounds awful, but doesn't sound like him, and then you hear person number 2 or person number 3 or person number 4 say the same thing, do you start to go, well, what are the chances? And that's the question that we want jurors to avoid. That what are the chances question isn't really the question they should be answering in court. The other issue at play here is that the prosecution was allowed by that judge to bring in potentially a bunch of Harvey Weinstein's bad behavior from decades ago that had to do with him, how he treated a valet, or whether or not he overturned a table at a restaurant during an argument, things unrelated to sexual assault, if he were to testify. Well, his defense is now saying that's scared him enough, prevented him from testifying. He wanted the opportunity to testify, but he didn't testify because he thought, if I get up and testify, the jury's going to get to hear about a bunch of decades old stuff that has nothing to do with this, and they're just going to hate me and they're going to convict me. Are those arguments going to carry the day? I don't know. We will find out. But do those arguments have legs? I think they do. Is it unfortunate that we're talking about this issue when it comes to this man? I think so too. End of the day, even if granted a new trial, he was convicted in Los Angeles of raping yet another woman and was sentenced to 16 years in prison. So have no fear. Harvey Weinstein is not going to be seeing the light of day anytime soon. Also this week, we moved down to Florida. Sarah Boone, you'll remember her. She's the woman accused of killing her boyfriend by leaving him zipped in a suitcase. There is this video we're not going to show you, but it is so painful of watching this person essentially in the last moments of their life struggle for air inside of a zipped up suitcase. But what's funny is at this point, what's making more news now than the bizarre circumstances of the crime is this game of musical chairs that she's playing with her defense attorneys. She's now on her 8th attorney. Many of her lawyers have withdrawn, citing disagreements on strategy. Her latest lawyer said, quote, "Miss Boone has some ideas about what should be done, what should not be done. I don't agree with those," adding, "Some things she wants done, I won't do." What's happening here? We got to read between the lines. As a defense attorney, I can tell you what this attorney is trying to signal when he says, "Some things she wants done, I won't do." First of all, you have to understand about attorney-client privilege. A defense attorney is never going to go into court and disclose conversations that he had with his client. Even talking about the substance of it without quoting your client is problematic for a defense attorney. This is about as close as you're going to hear a defense attorney get, is to say something like, "Some things she wants done, I won't do." That means, in my view, Sarah Boone wants something illegal done. Sarah Boone wants something unethical done. Sarah Boone wants some argument made or some witness called or some sort of, I don't know what, motion filed in court that this defense attorney is saying that's beyond the pale as far as what I ethically will agree to do. Attorneys can disagree with their clients strategically. In fact, that is the one thing that attorney doesn't have to take marching orders from their client on, is strategy. That's what they're hired for. That's what their legal expertise is for, is on strategy. But when you've got your client telling you, "I demand that you do X, Y, and Z," and you know X, Y, and Z to be either illegal or unethical or just against your moral fiber, that's where you're going to have problems. It is interesting to me, not only that we're on to the 8th attorney now, but these all attorneys seem to be hinting at that same idea that it's not just about a personality issue. It sounds like there's something that Sarah Boone is demanding be done in her case that attorneys just say, "I'm not going to put my bar card on the line for that." In any case, a judge has ruled that her murder trial will not be postponed, and it is set to begin in May of this year with a brand new attorney. We'll see how that all works out. But finally this week, Karen Reed out of Massachusetts, the judge overseeing the murder trial, has rejected a joint request from both prosecutors and defense attorneys to push Reed's court proceedings back again. Reed is the woman facing a second-degree murder charge from the death of her boyfriend. You'll remember this was the Boston police officer, John O'Keefe. Prosecutors allege that Reed struck O'Keefe with her SUV after dropping him off following a night out, and then left him to die in the snow. Lawyers on both sides have now filed a joint motion last week to postpone the trial, explaining that they're still waiting on cell phone records, DNA test results, and information from a federal probe into Reed's arrest and prosecution. The judge is denying that request, a joint request. What's happening here? Judges want to run a tight ship. Judges don't ever want to allow the calendaring of their docket and the timing of a trial to get out of their hands. And they are going to put constant pressure on attorneys, both prosecution and defense. To me, in my view, it seems at all times, because they feel that if they don't, it will lead to endless continuances. End of the day, are they going to get this continuance if they're still waiting on that evidence? I think absolutely so. I don't think there's any way a judge pushes both the prosecution and the defense to trial if they say that they're waiting on things as fundamental as phone records and DNA results. I don't think there's any way that that happens. But this is all you have to bear in mind in the backdrop of what has become a very contentious courtroom battle. The judge is watching the defense attorneys and prosecution in this case fight it out about every little thing. And I think the judge is saying to themselves, if I allow this to go on, it might never end. I'm giving you a firm date. We're heading to trial. Figure it out. But I'm almost positive that if they come back in at this next court date and say, we're not ready, and it's outside of our hands why we're not ready. We're not ready because the lab hasn't come back with the results, or a forensic analysis hasn't come back with the results. I don't think there's any way a judge pushes them to trial. In any case, Reed is back in court on February 26, with the defense expected to argue, get this, a motion to dismiss and give an update on a separate motion to disqualify the Norfolk District Attorney Michael Morrissey's office from prosecuting the case. Like I said, very contentious. All right, what's on the docket for next week? First, we're going to talk about the Rust Set shooting, where armorer Hannah Gutierrez Reed is going to begin her trial next week. The question becomes, how did live ammunition end up on the Rust Set to begin with? At all, any of it. Also, we're going to talk about a trial taking place here in Los Angeles regarding Rebecca Grossman. This is a horrible case involving a traffic accident that took the lives of 2 young children. The lead attorney in that case, Tony Bosby, has pointed the blame at former Los Angeles Dodger pitcher Scott Erickson, whom he alleges was driving a black Mercedes SUV just ahead of Grossman's white Mercedes SUV. If he's saying he caused the accident, he's the one that actually hit him, that's all playing out in court right now. She's facing up to 34 years to life in prison if convicted. Once again, I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ or at joshuaritter.com. But I just have to say that thank you again for joining me. Please like, subscribe, leave a comment, and I look forward to you all joining me next week.